Welcome to the Innovation, Business, and Law Center Speaker Series. I'm Jason Rantanen, professor at the University of Iowa College of Law and director of the Iowa Innovation, Business, and Law Center. Today we welcome Dr. Audra Savage, senior lecturer and McDonald Distinguished Fellow in Law, Religion, and Human Rights at the Center for Study of Law and Religion at Emory University School of Law. Dr. Savage's work intertwines history, religion, and corporate law to examine hidden threads in modern legal systems. She received her J.D. from Columbia Law School, where she was editor-in-chief of the Columbia Business Law Review. She then practiced corporate law for almost 10 years at both law firms and as in-house counsel for an Australian toll road developer in Alexandria, Virginia. In 2018, she received her SJD from Emory Law School, where she won the Gertie and John Whitty Prize in Law and Religion. In her work on law, race, and religion, Professor Savage defined racism as the use of black people to achieve the aims of white people without regard to the personhood, humanity, and agency of blacks, and conceptualized the Constitution as the founding document of a religion of race. If you haven't watched her talk on the religion of race, America's First Religion, I strongly encourage you to do that right after today's talk. Today, however, she'll be speaking on a new article that focuses on the public statements and pledges made by public companies this summer in light of the national reckoning on racism. This is the beginning of a multi-part project exploring issues of corporate accountability and disclosure on the issue of race. I'm now going to turn it over to Professor Savage, who will talk for about 30 minutes. After that, we'll have some time for questions and further discussion. Professor Savage, welcome.
Thank you, Jason, and thank you to the Iowa Law, Innovation, Business, and Law Center. We were in the throes of a global pandemic and a chaotic governmental response, and then Memorial Day weekend happened, and George Floyd was murdered. A world that was already teetering on the edge of chaos because of the pandemic fell off the cliff. I see my lecture here today as a way to describe my new thinking on a project, and I welcome your feedback during Q&A, which will prove invaluable, I know. So I want to begin by asking you a rhetorical question. Have you ever felt sad and or angry when looking at the shelves in the breakfast aisle of a grocery store? That was my experience growing up every time we passed the rows of Aunt Jemima pancake syrup and mix. I was ashamed to see her face on the bottle, as I thought that's how the world sees me, as Mammy, as just a submissive servant whose only purpose in life was to be used by others, as less than. So you can imagine how deeply satisfying it was on a Wednesday in June when PepsiCo, the owner of Quaker Oats, announced it would retire the Aunt Jemima brand. We then awaited the liberation of Aunt Jemima's relative, Uncle Ben, and there's been some movement on that front. PepsiCo's action to retire Aunt Jemima is a great jumping off point for describing my project. Seeing all of these companies release strong statements about systemic racism, police brutality, and pledging to fight it led me and others to question, how do we hold companies accountable for dismantling racism? And to do so beyond consumers on social media shaming companies into action. Black activists had lobbied PepsiCo for decades to remove Aunt Jemima. But it wasn't until people took to calling them out on Twitter and a TikTok video went viral that PepsiCo decided to retire the racist products. It tells me two things. It is indicative of a culture and a system that allow the company to ignore the concerns and protests for decades without recourse. And secondly, there needs to be an accountability measure to ensure that they actually do give the money that they pledged, but also to take steps to dismantle racism and ensure a product like Aunt Jemima doesn't happen again. And the idea of accountability is important because I do not trust companies to continue their strident claims against racism after this current moment has passed. After all, in the 1980s, PepsiCo divested from South Africa to protest apartheid, proclaiming that it was morally and legally wrong. Yet, after they purchased Quaker Oats in 2001, they continued the Aunt Jemima product. In other work, as Jason has mentioned, I have explored the manner in which the Founding Fathers created a national civil religion based on racism, and the manner in which that religion continues to order our jurisprudence and our society to this day. Bringing this idea of racism as a religion into corporate law then, I believe it is fitting to use the Judeo-Christian ideals of reckoning, repentance, and restitution to offer a path forward for corporations to come to terms with the current state of affairs, to grapple with their role creating and maintaining that state of affairs, and to repair the damage of centuries of oppression and develop the full potential of equality in America. The first focus of the project, Reckoning, will outline the reasons to hold public corporations accountable for dismantling systemic racism, reasons that extend beyond traditional economic or efficiency justifications. The next focus of the project, Repentance, will highlight the need for a new regime of transparent accounting for each corporation's past dealings and present interactions with racism. The final focus of the project, Restitution, will argue that it is not enough for corporations to be not racist. They must instead be anti-racist and adopt an intentional approach to dismantling racism. This approach would include developing certain metrics to gauge whether racism was actually diminishing, and then developing enforcement mechanisms to ensure those actions are taken. I think it is important to add a few notes at the outset. First, the focus of this project is on anti-Black racism in light of the global movement sparked by Mr. Floyd's murder. This is not to ignore or diminish the marginalization and oppression felt by other racial groups. Instead, this focus on anti-Black racism can provide a blueprint to address all forms of racism and bigotry in this country. Next, I note that the focus is on public corporations now, because some of the largest drivers of wealth in this country are public corporations, and to a certain extent, they are already accustomed to regulation and accountability. It is therefore easier to suggest a new anti-racist regime that can be integrated with an existing system of regulation and of disclosure and compliance. In a 2003 article, Professor Alfreda Robinson recommended making corporations responsible for past oppression of Black Americans by paying reparations. She introduced the term critical race corporate theory to describe this area of law, which blends corporate social responsibility with critical race theory. It is time to pick up the mantle from Professor Robinson and expand this to include a full regime for public corporations to actively dismantle racism in a systemic fashion. The first part for corporations to address systemic racism is reckoning. Reckoning means to calculate or estimate something, or essentially, to come to terms with something. It is time for corporations to come to terms with the fact that racism exists, and they have a role to play in dismantling racism that plagues this country. And at this point, I want to share with you a few statistics showing the lack of Black thriving for the community. Black unemployment was 5.8% in February of this year, and it rose to 16.8% in May. Black households have just a tenth of the wealth of typical white households. Among the Fortune 500 CEOs, only 4 are Black, and all identify as male. That number of Black CEOs hasn't changed in the past 15 to 20 years. As of June 2019, 4.1% of board directors were Black, representing only a half percentage point above the same level 10 years before. Black employees represented just 3% of chief executive and 1% of chief financial officer positions. Management committees of most boards are comprised mostly of white men. As of the time of putting together this project, these numbers are only estimates, as it is notoriously difficult to find accurate numbers regarding diversity for corporations due to the lack of transparency. What is clear, however, is that more is needed. Corporations have resisted addressing racism in a systemic fashion. There have been, and are currently still, efforts to recruit more diverse talent to the C-suite and to include diversity, equity, and inclusion trainings in corporate compliance programs. These efforts, however, have been met with modest success, as there have been no significant long-term changes to structural racism. Further, corporations instituted these programs not out of a sense of intentionally dismantling and addressing racism, but as a means of protection against anti-discrimination lawsuits. Even these modest efforts at addressing racism are now being met with resistance, as President Trump has vilified these type of trainings and seeks to remove them from the federal government. More importantly, these diversity and inclusion efforts, while important, are superficial in that they do not address underlying issues of income equality and suppression of thriving that corporations have perpetuated. For instance, many of the same companies expressing solidarity in the wake of Mr. Floyd's murder have contributed to systemic inequality by targeting the Black community with unhealthy products and services, and by failing to hire, promote, and fairly compensate Black men and women for years. The primary driver for corporations not addressing racism is twofold. First, there is a traditional belief that the market will correct any deficiencies inherent in the functioning of the corporation. Second, there is the belief that it is for government to solve society's problems and not business. The problem with these beliefs lies in the fundamental denial that corporations contributed and even promoted racism and the inequality facing Americans, and that business, as an institution, is somehow removed from society and is a sterile entity apart from the people and processes that exist. The reasons for corporations to address racism and for society to hold them accountable rest on the fundamental nature of the corporation and its role in society. The first reason is grounded in the concept of corporate personhood. As constitutional persons, corporations have constitutional responsibilities, I would argue. The second reason is grounded in the purpose of the corporation. They are to be stewards of resources on behalf of all stakeholders, not just shareholders. The third reason is grounded in the role of the corporation as a significant institution in society. It can help ensure our system of governance remains a functioning democracy. Not only is the continued success of democracy at stake, but if corporations do not address and dismantle racism, there are other consequences. There could be a loss of investment in capital as shareholders, particularly institutional investors, look to corporations to boldly and concretely address racism. Also, a failure to address racism will affect the company's public image and customer loyalty. Another consequence is an increase in shareholder derivative litigation, as well as compliance suits brought by the Labor Department. Almost immediately after the global uprising against American racism began, there were 3 separate suits filed in California federal court against the directors and officers of Oracle Corporation, Facebook Incorporated, and Qualcomm Incorporated, respectively. The lawsuits allege that the boards and the executive management teams of these companies failed to deliver on their commitments to diversity, despite SEC filings to the contrary, as evident by the mostly white and male boards and teams. It is time for corporations to reckon with the fact that there is systemic racism in America. It cannot continue to exist, and there is a need for corporations to intentionally address and dismantle it. There are 2 steps for corporations to do that. First, there is confession, and then there is repair. The second part for corporations to address this racism is repentance. To repent means to confess wrongdoing, and to turn away from such wrongdoing. Accordingly, it is important for corporations and society to understand fully the role that corporations have played in creating, perpetuating, and maintaining systemic racism in this country. Before creating a new regime to hold corporations accountable for dismantling racism, there needs to be a transparent accounting for each corporation's past dealings and present interactions with racism. If it is true that confession is good for the soul, then corporate owners and managers will greatly benefit from an accounting of their corporation's involvement in creating and maintaining racist structures from early American history until now. I propose the creation of a Truth Commission, modeled on the Truth and Reconciliation Commission of South Africa following the end of apartheid. The commission would be comprised of representatives from various stakeholders, private nonprofits already working to hold corporations accountable, such as the group Just Capital, government agencies, such as the Department of Commerce and Labor, business leaders committed to stakeholder primacy, such as members of the Business Roundtable, employee interest groups, such as the largest unions, and investor groups, such as the Council for Institutional Investors, and commentators, such as people like us, business and law scholars. A Truth Commission would lay bare all the practices surrounding racial oppression by corporations in this country, followed by an understanding of how these practices affected the course of race relations well into the future. Once the history of Black oppression is fully known and understood, it will be easier to adopt remedies to effectively address race discrimination, and such remedies will be more effective. The history that would be uncovered relates to slavery, Jim Crow segregation, convict leasing, anti-Black violence such as lynching, concerted opposition to the civil rights movement, and financial oppression such as the sharecropping system, forced migration, and redlining. Corporations had a hand in all of these practices. It would be the job of the Truth Commission to uncover them. The second work of the Truth Commission is to provide a forum for the disclosure of current policies and practices that contribute to systemic racism. In a reparations lawsuit against an insurance giant, the plaintiff, a descendant of slaves, claimed that Aetna's corporate predecessor unjustly profited from the institution of slavery by insuring slave owners against the loss of their human chattel. Aetna was able to use the financial success of insuring slaves to grow into the company that it is today, a large company that influences and shapes our healthcare system. It is currently a subsidiary of CVS Health Corporation. As such, CVS is now part owner of Aetna's past practices that maintained and perpetuated a racist system. Aetna has acknowledged this history and has committed to improving diversity in the workplace and financial pledges to various endeavors that will improve the lives of Black Americans. However, the leadership structure of Aetna CVS is still overwhelmingly white. Further, there continues to be highly problematic issues and racial disparities in the health and insurance coverage of Black Americans, of which Aetna plays a part. The proposed Truth Commission would be an important way for corporations, like Aetna, to account for their past and present interactions with racism. The next step in this is the action necessary to dismantle this racism and hold corporations accountable for doing so. Restitution is a final part of for corporations to begin truly dismantling racism. Restitution involves repairing the damage wrought by the wrongdoing. Accordingly, corporations can take concrete steps to repair the damage of systemic racism. This requires doing more than acknowledging past harmful practices or increasing the number of Blacks on the board or in the employee ranks. It is not enough for corporations, again, to be not racist. They must instead be anti-racist and adopt an intentional approach to dismantling racism. I propose a new regime, one that would outline the metrics and enforcement mechanisms for application to every public corporation, with the goal of ensuring flexibility for each corporation to develop its own strategy. The work of dismantling racism is complex. It will take many years. It is necessary to have metrics by which it can be determined whether corporations as a whole and individual corporations are successful in their attempts to diminish racism. This is the crux of the proposed new regime. How are we to know whether corporations are actually doing the work and achieving the desired outcome? As the president of the Ford Foundation says, Darren Walker, as he succinctly states, only when companies and management are accountable in ways that are quantifiable will we see real systemic transformation of corporate America. One readily available set of metrics that can be used are ESG metrics. Companies voluntarily report on environmental, social, and governance measurements as a means to assist investors in evaluating companies' progress on these issues. As the law firm Wachtell, Lipton, Rosen, & Katz suggests, these measurements could be revised to address anti-racism, racial justice, and equality. The framework of ESG is in flux now. There is currently an initiative underway to merge the various ESG frameworks created by different organizations and create a universal set of metrics. Further, in light of COVID-19 pandemic, its effect on employees, there is a heightened focus on adding another imperative to the framework, that of E, for employment, creating EESG. This view is championed by former Delaware Supreme Court Chief Justice Leo Strine Jr., who advocates greater focus on employees as a means to creating a more sustainable capitalist system. Since the concept of ESG is already undergoing review and these revisions, now is a good time to retool it to include the anti-racist approach corporations need to take. I propose a new framework called AESG, where the A stands for anti-racism. Racism affects and influences every aspect of employment, environment, social, and governance. And the metrics for each of these categories should be revamped to disclose this influence. While this type of information may already be captured in pre-existing metrics, it is important to explicitly call it out and name it as relating to racism. I'd like to offer a few preliminary suggestions for the type of metrics that could be developed using the new scheme of AESG. For instance, for employment, disclosure on wage data by racial, gender, and ethnic background. For environmental, pollution metrics for communities of color compared to predominantly white communities to gauge the effect of pollution on those communities. Social, gauging access to markets by underrepresented communities. Or looking at representation of people of color in contracts with third-party contractors, suppliers, vendors, and consultants. Governance, representation of people of color on executive committees on the board. Demographics of institutional investors and policies and practices related to addressing racism. These are just a few suggestions. Although the ESG framework provides a good starting place to begin developing metrics, the framework is limited. For one thing, until the universal framework is in place, ESG reporting, as it is now, is varied and subjective. Another issue is the voluntary nature of the reporting. It's up to companies to provide the information at their own volition. A third issue is a lack of incentive for executives and directors to adopt these measures, as their tenure with the company often does not last longer than a few years. The more important problem with ESG reporting is the fact that it is limited to individual actions and status of each company. As the intention is to address racism on a systemic level, a set of metrics should be developed that help determine whether racism is diminishing on a system-wide basis, in addition to metrics for individual corporations. This would be engaging whether racism as a whole is diminishing on a nationwide basis. I propose developing a specific set of metrics centered on the experience of Black Americans by using the work of nonprofit groups tracking the perception of racism by Blacks and racial progress along specified measurements. I would begin by building these metrics based on the Pew Research Center and the work of the National Urban League. The Pew Research Center routinely conducts surveys and analyses of racial progress as perceived by different racial groups. Further, the National Urban League produces an annual report called State of Black America, in which it tracks racial inequality using the Equality Index. The Equality Index was created by the League to provide a way to document progress toward economic empowerment for Black and Hispanic Americans relative to whites. They measure progress, or lack thereof, in the areas of economics, health, education, social justice, and civic engagement. There are specific measurements for each of these areas using data compiled from a variety of sources, like the US Census Bureau. The League has provided this report since 1976 and has noted there has been slow incremental progress from that time until now. Incorporating metrics used in this report, as well as survey data from the Pew Research Center, into a new regime for corporate accountability will provide good benchmarks as to whether racial progress is being achieved. As mentioned above, corporations have been unwilling or unable to address the fundamental nature of racism in American society. They do not have a convincing track record that they will voluntarily undertake the significant steps required to dismantle it. As such, there must be external pressure brought to bear on the corporation. I propose a legislative response modeled after previous legislation that expanded regulation on corporate governance and provided enhanced disclosure requirements. The Sarbanes-Oxley Act and the Dodd-Frank Act are two primary examples. A big component of the new law will require annual disclosure of a new metrics regime related to anti-racism, including AEESG, and data related to the experience of racism by Black Americans. The Securities and Exchange Commission already has authority for oversight of public corporations' disclosure. The Commission would work to incorporate the new metrics regime into the disclosure requirements, creating new regulations as appropriate. Under this law, each public corporation would be required to create a special committee on the board of directors dedicated to anti-racism oversight. The committee would be tasked with oversight for disclosure of a new metrics regime and developing the goals and actions to improve such metrics. It would be this committee's responsibility to ensure the company's anti-racism priorities align with the company's strategy and planning. State law could also provide a mechanism for holding corporations accountable. California provides a very useful model in that it is developing corporate law to further diversity efforts. It created a law a few years ago addressing gender diversity at the board level, and the state legislature recently passed a similar law addressing racial diversity. Although it only addresses diversity and only at the board level, it is the first state law of its kind and expands the possibilities of how society can hold corporations more accountable in order to achieve goals beyond shareholder wealth maximization. Another part of state law which can have a significant impact on corporate accountability is fiduciary duty law. Adopting a stakeholders theory where corporate managers consider a wide variety of constituencies in their decision-making on behalf of the corporation creates tension with long-standing conceptions of the duty owed by the managers to the corporation. This tension is expanded once the corporation becomes responsible for dismantling racism. And naturally, there will be numerous issues raised by changing fiduciary law in this manner, and I'll continue to develop this idea. A final group for holding corporations accountable are shareholders, in particular, institutional investors. One idea is to increase disclosure for these institutional investors and require more disclosure regarding their own accountability for racism. For example, racial demographics and metrics for each institutional investor. Another idea is to empower these investors to hold corporations accountable along the lines, as we saw with hedge funds, pushing for more accountability for climate change and gender diversity, like BlackRock or the Coalition for Inclusive Capital. I think it's also important to consider empowering shareholders to have more authority, including in the area of executive compensation, specifically tying executive compensation to achieving anti-racist metrics. A final means for shareholders to push accountability is a shareholder derivative lawsuit. The shareholder derivative lawsuits filed in California against Oracle, Facebook, and Qualcomm, previously mentioned, already provide examples that push for this kind of accountability. The shareholders claim, among other things, that by maintaining an all-white board of directors, each corporation violated its Caremark fiduciary duty by failing to adhere to compliance and anti-discrimination laws. The proposed remedies in the lawsuits include replacing current directors with diverse directors, creating a fund dedicated to hiring, promoting and retaining diverse employees, making 30% of executive pay tied to the hiring, promoting, and retaining of diversity goals, and directors donating all the 2020 compensation to organizations advancing the Black community. We won't know what will happen with these suits going forward, but they do suggest a way for shareholders to hold corporations accountable, and I doubt these will be the only ones that are filed in the future. Corporations issuing statements, pledging money, and retiring racist brands in the wake of George Floyd's murder gave rise to the hope that corporations would be part of the solution to address the racism that plagues and has always plagued our country. This lecture has outlined the contours of a new comprehensive regime for holding all public corporations accountable for dismantling systemic racism. I will develop this regime of reckoning, repentance, and restitution for the corporate person over the next several years. I invite fellow business law scholars to join me in this endeavor as we develop critical race corporate theory to hold public corporations responsible for dismantling systemic racism. I appreciate your time and attention, and I look forward to engaging with you and engaging in dialogue about these ideas. Thank you so much.
Thank you, Professor Savage. We're now going to open it up for questions. You can ask questions by typing them into the questions function in the Zoom webinar or by typing them into chat. I'll read the question if it's a short one and unmute the speaker if it's a longer one, so they can ask it in their own words. So just as a reminder for everybody, the talk is being recorded. So if you do ask a question, just be aware it is being recorded. All right. So I have one question here already from an anonymous attendee, so I'm going to go ahead and ask that one myself.
Sure.
All right. So where does developing entrepreneurship in African-American communities fit into critical race corporate theory? What effective policies to promote such activity are there, especially given the history of attacks on business creation and wealth creation in African-American communities, such as Tulsa, redlining, discrimination, and property appraisals?
Yeah, it's a great question. It's important. And that's really good for me to consider going forward. I have not included Black entrepreneurship into the project quite yet. It's something I am thinking through. Being here in Atlanta right now, it's called the new Black Silicon Valley. So a lot of starters and promoters moved from California to Atlanta because they found it more friendly to create this community of Black startups. So definitely thinking through that. And I guess one thing is I feel like in order to actually help promote Black entrepreneurs and promote small businesses, we still have to get to the root of the problem, right? So the issues have been redlining and the history of financial oppression. Unless we address those issues, they're still going to continue to develop, right? So when a small business is going into the bank for a loan and they're going to have rejection at higher rates than other businesses would have, or they're going to have higher interest rates and more punitive terms, punitive terms. I think that's part of the problem. So we have to get to those core issues regarding the economic system and the corporate system as a whole. Otherwise, by only focusing on promoting Black entrepreneurship, we're still replicating the same problems because we have to get to the heart of the issues. But it's a great part, and I definitely want to give a story to Black entrepreneurship into this project for sure.
I have another question here. Are there any corporations you feel have started to rise to the occasion and meet the moment since George Floyd's death?
Yeah, I think one of the strongest expressions of all these public statements, and I had a little bit of their statement up there, is Ben and Jerry's. Now, to give credit to Ben and Jerry's, they've been involved in issues of social justice and promoting and being more of a public benefit corporation in terms of promoting corporate social responsibility, stakeholder primacy, really being part of the community and being part of our economy. But they really had, I think, one of the strongest statements against white supremacy. I think it actually said dismantle white supremacy. But more than just their statement or their actions, for a number of years, they've looked at their supply chain to see where they can be more anti-racist. And one way is they're asking their suppliers, I believe in upstate New York, to make sure that they hire all people, regardless of their felon record or their background or their interactions with the criminal justice system. Because we know a large part of the mass incarceration system are Black and brown men, primarily men, but also a large number of women going into the system, coming out, and then being prohibited from getting jobs and prohibited from actually having economic thriving. So one way that Ben & Jerry's is addressing that is ensuring that suppliers hire all people who are capable regardless of their background, which, given the prominence of mass incarceration in our society, is important. So I think that Ben & Jerry's continues to have a role model for that. Now, in terms of a company that perhaps didn't have that strong statement and then now wants to have more action, I think PepsiCo actually, not only did they have their company Quaker Oats retire and Jemima, but they actually pledged around $400 million, I believe it was. And then later, a few weeks after that, have actually given concrete steps of what they will do to begin addressing racism. Now, I applaud them for that. I applaud all companies who actually want to be more transparent and more open, start replacing board of directors. I think the only challenge for us there is that it does two things. First, it continues to do the same thing in terms of just increasing the number of Black people on the boards or employees, which I say is part of what we want to look at and part of our metrics and enforcement. However, if that's all they do, that's not actually helping the problem. We saw companies in the early 2000s, actually in the beginning of the 80s and 90s, add more Black people as CEOs and try to add more Black people and people of color and women to their boards, but we haven't seen that movement. And so only addressing the employee part or the director's part only gets us part of the way there. Another problem with corporations and their recent actions and their donations to, for instance, I mentioned nonprofits that are advancing the Black community, like the NAACP or National Urban League or these groups, or giving a large number of money to HBCUs. That's also helpful. And I would never say don't give money. Money is always helpful because it's America, right? But part of the problem is it's now offloading responsibility to someone else. Now it has to be the HBCUs, NAACP, National Urban League, the people who have already been fighting for against oppression to continue the work. And now corporations can say, well, we gave money to the effort. And now we have, 1 or 2 internship training programs and at HBCUs. That only still gets us part of the way there. So I really haven't seen a corporation fully invest itself. I've seen a lot of talk, and I've seen members of the Business Roundtable even really coming out and having strong anti-racism and saying we're going to devote ourselves to the cause. But I think it's too early to actually determine if their actions have met their words.
All right, the next question I have here is how to determine who is Black. Is the one-drop rule still appropriate? Self-definition? I think this goes to some of your questions of personhood.
Mm-hmm. Yeah. So in terms of corporate personhood, I won't be looking at so far. This is thinking, and maybe I'll add some notes and think about that. But in terms of corporate personhood, I'm not as interested in defining a corporation as white or Black. The approach is, if the Supreme Court has deemed all corporations to be persons, and they have constitutional persons, then for me, it means all corporations have constitutional responsibilities, which include a redress for harm. It includes a redress for unjust enrichment. And so I think that that's irrespective of whether we would deem a corporation to be white or Black or to have a racial identity. But it does get as a good question in that there are, and there's been a little bit of a movement of corporations, particularly small businesses owned by racial minorities and by women, to declare themselves, if they're persons, to declare themselves as a racial person, and therefore they've been discriminated against by not being able to get government contracts and such. So I think that's a very important issue, important thing to think about. But as far as my project is right now, I'll give it some more thought. I'm not as concerned with defining a corporation as Black or white. But I'm reminded by your question, and I think it's one of the issues and one of the problems that people are already raising regarding the California law on racial diversity. Right now they have a set number of members of the board have to be of a racial minority, or it's racial, gender, LGBTQ, have to be of difference from a marginalized community. And the problem is self-identification, right? Who is Black, who is white, who is considered to be gay, who's considered lesbian, right? And how do we define that? And we've seen recently, not to disparage a fellow academic, but we had a recent case of a white woman claiming for a number of years to be a Black scholar. And so these issues are arising. How do we actually deem someone to be Black? And so something to think about going forward. In the one-drop rule, that's a whole different lecture and a whole different talk. It's something that I won't be addressing in this project. But feel free to find me afterwards and we can discuss offline.
I have a question, which is, I know this is still early in your project, but thinking about some of your remediation pieces of it, your restitution pieces of it, a lot of the mechanisms you talk about, disclosure, governmental regulation, they've been tried in other areas like the environment, and yet we still have major environmental issues. So I'm kind of curious about whether you think that this is a particularly good area for those types of governmental interventions, or whether you think that we're still going to have a polluted environment, we're still going to have these continuing issues despite governmental interventions like that.
Yeah, that's a great question, Jason. Particularly because, and to your point, so we've had ESG for about 10 years or plus. Like I said, it's there are commentators who work solely on that and actually criticizing it and being critical of it and helping to advance it and make it better. Because one of the problems is, so you have a company that discloses, right, that perhaps it's not the best when it comes to climate change, that it has violations in ways that actually damage climate change, but then so what, right? They still get shareholders, they still get equity and investment, and there's no outcome. I'm thinking of after Dodd-Frank, for instance, a law that was created, and to your point, Jason, created in the wake of the recession, 2008 Great Recession. Although I feel like we're on the cusp of another Great Recession, like how many Great Recessions are we going to have, right? But Dodd-Frank has a part of it that says you have to disclose your interactions with conflict minerals and your use of conflict minerals. Well, Nintendo disclosed that it was doing a really poor job with that, and violative of that, but their shares continue to rise, their products still sold. So it's this idea of, even if the law intervenes and the government intervenes and you have these disclosure requirements, then what? How does that really get to affecting regular shareholders who are not institutional investors, but also the public, us? And so that's one part of it. Right now I'm proposing a regime, because for me, the AESG and even creating new laws to have external pressure, that's the lowest hanging fruit. What I do want to start developing, think through, Jason, is this idea of non-legal groups, right? Making it extra legal. What do we do as a public? How do we hold corporations accountable? Right? That's kind of the next frontier. How do we hold the Nintendos of the world who are using conflict minerals? How do we hold companies that we know are not addressing climate change in a meaningful way, that are responsible for it, but not addressing it? How do we actually hold that? And it has to be more than just disclosing it in a few paragraphs and SEC filing that 99% of the public won't even know about or read. So definitely is the next frontier, and I look forward to hearing different people's ideas on that, because it has to be, obviously as a lawyer, I want to focus on the law because the law does have the ability to give so much promise, but I think that we have to move beyond that and explore beyond that, which is one thing I hope the Truth Commission would do if we actually were to create this, right? And that it's comprised of not just lawyers, not just business people, but also nonprofit groups, also people from public sphere, institutional investors, unions, so that we're all coming together to actually find solutions beyond just the SEC having regulations for the corporation.
Well, thank you very much, Professor Savage. We are unfortunately out of time, so we're going to end for today. But thank you again. I would like everyone to, hopefully, if you can join us next week, Professor Cassandra Jones-Havard will be speaking on Wednesday. So departure from our normal time, but we'll be on Wednesday next week at 12:45. I hope you all can join us then. Thank you all.
Thank you all. Have a good one.